Thanks, everyone. And it's great to be here again. I really appreciate it. Going to be doing an overview of many things, but as things crop up in my office, I think it's important to talk about. So I'm going to be talking about the various documents that seniors should have as they age. But now I'm going to be focusing more on the capacity to execute those documents. We've been getting a lot of cases in this regard, a lot of complaints with the powers of attorneys, the trusts, even the healthcare proxies. There have been disputes. So I'm going to focus on that. I'm going to talk about living trusts a little bit, talk about the estate tax changes, which we have now, and also Medicaid changes, some of which just started a couple of weeks ago, September 1, which will, I think, drastically affect Medicaid home care in New York. So let's get going. All right, here's my bio. I think Diana's going to send out the slides to you. So these are the documents that I think are essential for almost everyone as they age. It's the last will and testament. You know what that does. The power of attorney, but just not the form that you have in the general obligations law. This is going to be an elder care, an estate planning power of attorney that's going to add other provisions into that power. And we're going to talk about how that plays with the capacity of the principal. A power of attorney is a principal agency relationship. Well, we've been seeing a lot of principals that come into our office and their capacity is questionable. And some of those powers of attorneys have extensive gifting provisions. So we have to be very, very careful. And you want those provisions for Medicaid, because if this individual should become totally incapacitated in the future, you really want to make sure that you could jockey assets back and forth. But is there fraud? We just spoke about fraud and the new FinCEN rules and all of this. Well, there's fraud all over the place, and including the work that I do. The healthcare proxy, the living will, and the living trust, and how this all plays together. And we're going to go into the new items that have cropped up, unfortunately, with Medicaid home care. So let's start with the power of attorney. Everybody knows what the power of attorney is. It's where you have a principal who gives the right to someone else to handle financial matters. And just the form of a power of attorney, I think, is sufficient for a real estate closing. But as you age, when someone's over 55, 60, 70, they really want a more comprehensive power that includes the right to gift assets, the right to disclaim assets, the right to create a trust, revoke a trust, modify a trust, to do Medicaid planning, to do estate planning. The list just goes on and on. But unfortunately, lately, we're seeing some potential clients that come in that have questionable capacity. So the power of attorney is essential, but the power of attorney that you may use for a closing is great for that closing. It may not be good enough to do planning later on, which may require extensive gifting, the right to execute on a power of appointment in a trust, which I'll explain later on. But we draft trust provisions within that power of attorney so the agent on the power of attorney can actually, if the principal and the grantor of the trust cannot do what he or she needs to do, the agent on the power of attorney can effectuate a plan, such as basically setting up disclaiming assets and doing other items within that trust, like the power of appointment, which is absolutely crucial at times. we have that power in the power of attorney if the grantor of the trust can't do it. So the two docs go hand in hand. And let's talk about capacity to sign a power. Uh, the individual has to understand the nature and the consequences of what he or she is signing. So they have to know the purpose of the power. They have to know that the agent will be acting on their behalf and making decisions on their behalf. But you have to know, just because that power of attorney could have all of these provisions in it, the right to gift, the right to do everything, that agent has to do what the principal wants. And if the agent doesn't know what the principal wants, the agent has to act in the best interest of the principal. Okay. The individual, the principal, must understand the specific powers that are being given. And we draft our power of attorneys, they're so broad because as you age, the chance of becoming incapacitated increases. And we need to have that agent do so many different things. And if we limit the power and the window shuts and the principal doesn't have capacity anymore, we could be stuck. We may have to go to court and have a guardian appointed, and I don't want to see that for my clients. So the principal must understand the specific powers, especially the right to make gifts, manage their finances, etc. The principal must know that he or she has the right to revoke. What if the principal named son A as the agent on the power of attorney solely, but child A has become estranged from the principal? That power of attorney could be revoked. The principal needs to understand that. Okay. So here we are. We're the attorneys. And many times we have this judgment call. Client comes in to sign a power of attorney like these other documents, and we have to make that judgment call to basically evaluate, is the principal competent enough to sign the docs? So of course they have to be oriented to time and place. They have to have the attention span to have a conversation. They have to have, the memory to do that. If you think there might be an issue, but that principal basically has capacity, it's a good idea to get a neurophysical evaluation, have a doctor say that this individual is lucid enough to sign documents, and if they don't want to say that, at least that they have lucid moments. Because again, in signing documents, all you need is a lucid moment. And with many Alzheimer's clients, they may be lucid in the morning, but they slowly lose capacity towards the end of the day, and that's called sundowning. So you want to schedule the time to sign that power of attorney when that individual is lucid. And if you're not sure, what we do, we bring in another attorney, sometimes two attorneys, and we will never, ever, neither should you, ever have a principal sign a power of attorney or any documents if they don't have capacity. You might get a lot of please, please, pleases from the family. They might be a tight family that you've known for the last 25 years. Don't jeopardize your law license. Just don't do it. The power of attorney is signed before a notary and two independent witnesses, and one of the witnesses can be the notary. Okay, what about the healthcare proxy? Well, for that elder care power of attorney, you should have an elder law attorney drafted. It's going to be drafted specifically for that individual, and we're going to add Medicaid provisions and all sorts of provisions to that power of attorney. On the other hand, the healthcare proxy is really a very simple document. You could prepare it yourself or your client. Your client could prepare it himself or herself. The principal has to be 18 years of age or older, and the healthcare proxy simply delegates the right to a proxy, to an agent, to make their healthcare decisions only when they can't make them. So you're not giving anything up. It's pretty simple. And the capacity to do this is quite simple. The GOL says they have to understand, again, the nature and consequences of the document. And the individual doesn't have to be terminally ill, because we get that question a lot. Everyone should have a healthcare proxy. The law came about in 1991. I've had my proxy since 1991, just in case. The proxy requires two independent witnesses, no notary. And there is a presumption of capacity to sign that healthcare proxy, which is great. No notarization. Once it's signed, you have the two witnesses. It's legally binding, and we're good to go. They don't need a lawyer, and they could do it on their own, or you could prepare it for them. Many of you may not know about the Family Healthcare Decisions Act, but this was many, many years in the making, and I was very active in trying to get this to become law. And it became law, I would guess, maybe 15 years ago. But it basically says, if there is no healthcare proxy, basically family members can make decisions for an individual who doesn't have capacity if they are institutionalized in a hospital or a nursing home, a residential healthcare facility, or at home on hospice. Those are the only times. And the first thing that everyone would look to is the healthcare proxy. So make sure that your client has that healthcare proxy. Don't rely on the Family Healthcare Decisions Act, but it lets family members, there's a hierarchy. It also even lets Close Friends Act. And again, on the healthcare proxy and the Family Healthcare Decisions Act, what decisions are made? Of course, it's the decisions that the individual wants for their own body. So when you have a client sign a healthcare proxy, there has to be lots of communication between the client that signed that proxy and the individuals that they named as agents. Same thing with the Family Healthcare Decisions Act. Family members that might be making these decisions, if there's no healthcare proxy, they need to know what decisions to make. What about the last will and testament, where your assets go when you pass away? A couple of caveats. You know what the will is. First day in law school, this is what you get. But you have to really think about it. If you do that last will and testament, you prepare it for your client, you really have to go over all of their assets. And you know, as well as me, that the last will and testament does not cover any assets in a living trust, number one, and does not cover any assets that have a beneficiary designation. So how many times do I see a great will, but the attorney didn't look to see were there beneficiaries designated on one asset or another? And will that change how the assets go to the children? Maybe it won't be equal. Maybe it will be equal. It could be a little bit of this, a little bit of that, and mishmash like that is not a good thing. So you have to go over all of the assets that your client has when you do the will to see what assets have beneficiaries designated, see if that still is consistent with the plan that the client wants. What about the capacity to sign the will? Number one, same thing. Person needs to understand the nature and consequences of signing that will. They also have to know the natural objects of their bounty. How archaic to say they have to know who their close family is, who are their friends, how many children they have, what are the names of their children. right? So they need to know that. They also need to know about how much in assets they have. So I recently saw a client, very nice guy. He was frail mentally. That's the way I would describe him. But, he seemed to have decent capacity. We had a conversation. He is concerned about his kids. And I asked him, "Do you know the name of your children?" Took him a while, but he mentioned the name of his children. And then I said, "Mr. Jones, how much in assets do you have?" And he said, "Oh, I think I have a lot of money. I think I have $5,000." I said, "Oh, okay." Uh, and waited a little bit and said, "Mr. Jones, about how much assets do you think you have?" He said, $5,000. It's not a lot, but I think it's enough. So knowing this client for years, he had an excess of $5 million. Does he have capacity to sign that will? Absolutely not. Absolutely not. Last thing on the will, no undue influence. I see this all the time. You're dealing with three children. And I get this all the time. I do elder law work. I dealing with the three children. One child is in California. The other is God knows where in Texas. But one daughter is in New York. And that daughter in New York calls you up. Said, "Oh, mom wants her will. She wants to provide, 75% to me and 25% to my siblings." And you could ask her yourself, and this is what she wants, but speak to me. Well, doesn't smell kosher. We smells like there's going to be an issue. And then we speak to the client, and many times you got to speak to the client alone. The client might say something like this: "I'm so afraid. My daughter is so powerful, and she's so strict with me on this. I love all my children equally, but I'm afraid if I don't do what my daughter wants, then she's not going to help me anymore, and I'll be all alone. I'm 90 years old." My heart goes out to these people, and I've seen many circumstances just like that. That is undue influence and is not to be accepted by you or me or anyone. So make sure you sniff that out. Don't listen to a child, and good practice is that you have to meet with the individual, not just for the will, but for all of these documents. Look, if the agent on a power of attorney could make gifts, and gifts to the agent himself or herself, which we put down a lot. But sometimes you may want to put in that power of attorney that all gifts to the children have to be made equally, or something, some equalizer, if that's what the client wants. All right, you know that the individual, the testator, has to be 18 years of age or older, etc. But be careful about that undue influence. I see that a lot. Living will, only going to spend a minute on this. It's not a statutory document, but it's the forum where the client will say exactly what he or she wants. I want you to know that a living will, can be tailored. Had a client I just saw yesterday. She was very adamant. She does not want to live if there's no chance of recovery. And she said, I'm closest with my son, but he can't let go. He won't let go. I'm naming my daughter. Many times we have a husband who won't name a wife. She can't pull the plug. I don't want to stick around. Or maybe your client wants to stick around, whatever it might be. But make sure you ascertain what the client wants. If the client, for example, is Orthodox and Jewish, we have halakhic living wills, and we just did one this week for a client. So you got to think about who the client is, what they want. And I love it when I deal with doctors and they go into all of this. And I said, you have to think about the new technologies are coming into the future. You have to keep it broad and a little bit vague because you don't know what's coming down the pike. And you also know that healthcare wishes, medical treatment has to be established by clear and convincing evidence if there's a dispute. And we have had disputes in the past, regarding what that client really wanted, if that client really had capacity when he or she signed the living will and the healthcare proxy, etc. You don't need witnesses for the living will. It's not statutory, but it certainly is a good idea. And you definitely don't need notarization. What about the living trust? Again, you got to be 18 years of age. You have to understand the nature and consequences of the trust. The individual, again, has to know what property they have. Not exactly, but more or less. And what property they're transferring into the trust. They also have to know the natural objects of their bounty, who their family is, their close friends, etc., and the effect of the trust on their overall estate plan. So you got to be careful. Are the beneficiaries on that living trust the same as the beneficiaries on the will? Sometimes a court won't look at that, too well. And, they wonder if there's an issue here with capacity. So you do have to be very, very careful. The capacity to sign that trust is very similar to the capacity to sign the will. The grantor, the creator of the trust, has to understand who the beneficiaries are, the relationship that he or she has with the beneficiaries, and what the beneficiaries will benefit. And if there are 3 children, maybe you want to give it to one child, but they really have to understand. And just know, anytime the assets aren't going to the children equally, there could likely be a contest of the will, and you could have a contest of the trust as well. A little more difficult, but there can be a contest of the trust. So you have to pull out all stops and get witnesses when I think there might be an issue or assets are not going equally to the children. Yeah, you only need 2 witnesses on a will, but many times we have 3 or 4. And not only that, they sign a contemporaneous affidavit talking about the capacity of the grantor of that trust or the testator, of the will. So you got to be very, very careful. And again, for the trust, you might do it with the 2 witnesses, but you could also do it with 4 witnesses, and make a better case for yourself. And also, you could always go to a physician and have the physician say that the individual has lucid moments. Again, ethically, because this happens. The daughter, the son reaches out to you and says what mom or dad wants or what their wife wants. You can never presume that this is what the individual wants. And many times they say, oh, no worries, we live in upstate New York. Just do the work. We'll pay you for the work. And just, send the document to us. Scan it, send it. We'll print it out. I'll have mom sign it. Never, ever, ever do that. Even with the power of attorney, or maybe I should say, especially with the power of attorney. That is a big no-no, especially when that power is broad and could have incredible negative or positive ramifications. Okay, so now we're going to talk about Medicaid for a little bit and some of these items. You should know that if an individual doesn't have capacity and needs a guardianship, once we file that petition for guardianship, the court gives us tremendous leeway because in almost any situation, we do guardianship actions all the time, which means that clients should have done the good powers, the expanded powers long ago. and the healthcare proxy and the living will long ago, but they didn't do it. So here we are. We're doing a guardianship action. Just know that in every situation that we brought this guardian and we needed to do Medicaid planning, the court allowed us to do it. And it's based on substituted judgment, the second bullet point. The court basically looks to this incapacitated person and says, would this person have wanted to protect the home for his or her children and put the home in a Medicaid trust? Would this person want to protect the other assets that I have? And the answer is 99.9% yes, which is why the courts have consistently permitted Medicaid planning to be done by the guardian on behalf of the incapacitated person. So in order to go on Medicare, you have to be 65 or younger and have a disability for 2 years, etc. But in order to get Medicaid home care or nursing home care, the asset level is pretty low. It's only $32,396 this year. So it's not much. And the well spouse could only have about $158,000. You should know that we have the concept of spousal refusal. We still have it. What's the status of spousal refusal in Medicaid cases right now? The answer is, in most cases, New York City, the 5 boroughs, Nassau and Suffolk, and Westchester, they're not doing all that much. When a well spouse signs a spousal refusal, they're typically not going after that well spouse, but they can. And if the well spouse has a lot of assets, then that's going to be an issue when they likely might go after that spouse. But we are getting letters, in New York City as well. The spousal refusal, we could go after you, well spouse. And that's the way it is, and the courts have allowed it. The well spouse in the community keep $158,157,920, an income of close to $4,000, $3,948. If the Medicaid applicant is getting home care, he or she could keep income of about $1,820 a month. But then we have that pooled income trust where that individual could keep virtually all of his income to use to pay for expenses. So it really works. Spousal refusals work. You got to be careful because there could be spousal suits. So how do we handle that? So let's say the client has, picking a number, $500,000 in liquid assets, $500,000 in IRAs, let's say, and the home. So home is worth $1 million, let's say $2 million. The IRAs are exempt. I don't know if you guys remember from last year's seminar, but I changed the law on that about 20 years ago with a case I had in Queens, New York. Even without litigating, but with briefs going back and forth, New York City said that retirement accounts and payout status are exempt. So we're good with that. The home, we have some issues with the home. So let me get to that for a second. Here we go. On the home, we have a home equity limitation, but that figure went up to almost $1.1 million. And it's going to go up even more starting January 1. So you have too much in assets if the equity in your home is greater than $1,097,000 for Medicaid, except if there's a spouse, minor, blind, or disabled child living in the home. Let me backtrack a little bit. Okay. So be careful with the spousal refusals and what we want to do. And even if the, New York City or Westchester, they come after our client, we make a case to say why that well spouse needs those assets, or we negotiate with them. The regional rate, let's just take, Long Island is about 15,000. Westchester and New York City is about 14.5. Let's say that the regional rate is 15,000. So Medicaid looks back 5 years to see what assets the individual, and if there's a spouse, individual and the spouse have. And they look back 5 years, but the 5 year look back right now is only for nursing home care. We thought that there would be a 2.5 year look back for home care. It's still on the books, but it's likely about a year away. So it's not here yet. But for nursing home care, Medicaid looks back 5 years at the applicant and the spouse, and they look to see what gifts were made. And if there is a gift, just look at this regional rate. If you're in Westchester and you see that the regional rate is 14,569, for every 14,569 in assets that are gifted, there's a 1 month wait where Medicaid will say, okay, you could go on Medicaid, but you're going to have to wait 1 month because you gifted assets to get down to that Medicaid level of 32,000 plus you could keep the retirement accounts, as I explained before, and in most instances, the home. So that's how it works. I know I don't have much time, but this slide goes through the exempt transfers where these gifts can be made, but Medicaid says fine. And the basics are gifts to the spouse, even at the last minute. Gifts could be made to the spouse. Client has that 500,000, can only keep 180,000 or 60,000, whatever it is, doesn't matter. Transfer the assets, a full 500,000 to the well spouse, let her sign a spousal refusal because that's an exempt transfer. Any disabled child can receive money from an applicant. That's an exempt transfer. When it comes to the home, transfer to a spouse is exempt. Medicaid could look back 5 years. Why do you want to transfer to a spouse at a minimum? Because what if the well spouse dies, owned by tenants by the entirety? The well spouse dies. You don't want the spouse that's on Medicaid to get the home. Medicaid could recover against the house later on. Also, if it's the home, any transfer to a disabled child is exempt, but they also say that a transfer of the home, the primary residence, to an adult child who's a caregiver for at least 2 years, or a sibling, a brother or sister who had some equity in the home for just 1 year, that's also exempt. So we do a lot of strategy planning around the home regarding that. So the advantage to the Medicaid trust is incredible. That's why we do a trust. If you just do an outright transfer to the children, they'll get the basis. So if client bought the home 30 years ago for 100,000, but now that home is worth $1 million, and you transfer that home outright to the children, they're going to get that low basis. If you transfer it to the children and retain a life estate in the deed, you'll get a basis step up. But what if that home is going to be sold? It won't work out. So the trust is typically the best way to do it. You'll get a basis step up at the time of death. You'll even retain that $250,000 capital gains tax exclusion, the 121A, Internal Revenue Code Section 121A, and $500,000 for the spouse. So in that trust, the home could be sold, the client could downsize, they could upsize, they could rent out the home and get the income, but it's protected for Medicaid. Best way to do it typically. So I'm going to talk about this. I'm going to end my portion. So we have new rules effective right now, September 1, regarding Medicaid home care, the old criteria, old meaning 18 days ago, prior to September 1, you only needed one activity of daily living to qualify that applicant for personal care services or consumer directed personal care services or managed care, one ADL. You needed assistance with bathing, dressing, feeding, toileting, continence, transferring, for example, bed to commode or bed to chair, ambulation, things like that. Only one. Now you need three ADLs. Three ADLs with regard to physical maneuvering, with regard, at least, there has to be some limited assistance. Went from one to three. So a lot of people will have issues qualifying. We do the Medicaid applications in our office, and this is what we do. We try and we work very hard with social workers who go in for the assessments, and we try to get the hours for our clients. Now, if that applicant has dementia, the ADL requirement goes from 3 to 2, but not with maneuvering the individual or with assistance, but with supervision. Make sure they won't fall. It's cueing, it's guarding, etc. But they're still going to need help with bathing, dressing, feeding, all of that. So you have to keep this in mind. We do have something known as legacy status. So if the client was assessed prior to September 1, but actually gets accepted afterwards, there's legacy status. They'll be grandfathered in. And there's some other items with regard to legacy status. So just want to say one last thing. Don't let the one big beautiful bill fool you. Yes, President Trump made the exemption for federal gift and estate taxes. It's going to go up to $15 million come January 1. And yes, it's permanent. But yes, it is permanent, as many people have said, until the next administration comes in. So you need to do planning, not just for federal purposes, but we have that $7 million estate tax exclusion in New York, and we have the cliff issue. And yes, we don't have a gift tax, but we have a clawback that's made if any gifts are made within 3 years of death. So we may consider spousal lifetime access trusts like SLATs or ILITs if there's life insurance. That's what we have to do. But don't just think you don't have to do planning for a middle class individual that's creeping close to that $7 million New York State level. Planning should be done. I know my time is up. I apologize if I went a couple of minutes over, but thank you so much. I am going to stop sharing my slides. Okay, thank you.
So while we're transitioning, I figured I'd give everyone the course code. The course code for this lecture is PLAN. The course code for this lecture.
Oh, so we're on mute, I guess. I'm sure.
Thanks, Ron.
Thank you, Ron. Appreciate you. You're mute.
Yeah, no, I can't wait to hear what you guys have to say. That's for sure.
Of course, yeah. All right, so good afternoon, and thank you guys for having us. My name's Thomas Airey, and with me is my partner, Evan Mannello, both registered representatives with New York Life, and today we'll be walking through some strategies for protecting estates and families from the financial impact of long-term care. Now, our goal is to show you how long-term care insurance, asset flex, and cash value life insurance can complement your estate planning work. Now, together we work with clients to design strategies that protect assets, preserve legacies, and ensure that estate plans succeed when they are tested. Our office is based in Melville, New York, and we specialize in collaborating with estate attorneys like yourselves. Now let's begin with long-term care. One of the biggest threats to any estate plan is the potential cost of extended care. We often hear clients say it won't happen to me, but the reality is that a significant percentage of people will need care at some point in their lives. Roughly 70% of people will have a long-term care incident at some point, and these costs can quickly erode assets that were meant for their heirs. And by planning for long-term care, we are not only planning for health needs, but we are also protecting for the estate. Now, traditional long-term care insurance reimburses for care expenses, often covering around 80% of costs, with limits based on daily or monthly benefit amounts. Importantly, it could cover professional services as well as family-provided care. There are also potential tax advantages depending on how the policy is structured. While traditional long-term care is a strong option, New York Life has expanded its portfolio to include asset-based solutions, which can give clients and their attorneys even more flexibility. Now let's consider Caroline. In year one, she has a home health aide who covers about, for the long-term care expenses, about $2,000 a month. For 80%, New York Life will reimburse them, so it would cover around $1,600, 80% of it. And then in year two, now she goes from her home health aide, and now she has to go to an assisted living facility, which would now increase it to $4,000 a month. The long-term care policy would reimburse her the $3,200. So given that 80% again, having that policy supported by the family and by professional care is, hugely abundant. And this is what traditional MyCare, gives them. And from an attorney perspective, traditional long-term care is invaluable. It prevents the forced liquidation of assets to cover care costs, preserves liquidity for trusts and estate settlements, and adds predictability to planning. You can draft trusts and wills with more confidence, knowing the funding is in place to make them effective. Now, Secure Care is New York Life's individual long-term care product. It covers at home, in the community, or in a facility. It offers bundled benefit levels, for example, Secure Care 100, 150, or 250, and includes valuable features like dividends after the 10th policy year, a 25% discount for couples who apply together, and benefits like restoration of pool after recovery and waiver of premium while on claim. Now, in the second case study, we see John here has a Secure Care policy. He selected the Secure Care 150, which provides a lifetime maximum benefit of $164,250 and a daily benefit of $150. Now, at age 80, John is required to go into a nursing home care at exactly $150 a day. Now, his policy will cover the cost in full, and after he recovered, his benefit pool replenished thanks to the restoration benefit. And while he was receiving care, his premiums were waived. So this meant that John's personal assets remained untouched and were preserved for his children. For attorneys, Secure Care is especially useful because it ensures that the funding is there for client goals like trusts, charitable giving, or legacy transfers. It gives confidence that unexpected care costs won't derail the estate plan, and with discounts available for couples, it's an accessible strategy for many families. Now let's move on to Asset Flex. This is our hybrid product that combines long-term care benefits with life insurance benefit. It works in what we like to call like a live, die, or quit principle. So if you live and need care, you could use it for long-term care benefits. If you pass away without needing any care, your beneficiaries will receive a life insurance death benefit. And if you change your mind and you choose the return of premium option, you can get some or all of your money back.
Asset Flex is flexible in how it can be funded. Clients can choose a single premium, a 5-year, 10-year, or 15-year plan, or even payments to age 65. This makes it a great option for repositioning idle assets like money sitting in CDs or low yield accounts into something more productive. For attorneys, the appeal is clear. No matter what happens, the client or their family gets value from the product. It guarantees value preservation, adds flexibility for uncertain futures, and makes it easier to explain options to clients who might worry about wasting premium dollars. For attorneys, Asset Flex is compelling because it reassures clients that their money will not be wasted. It fits neatly into trust structures and provides liquidity. It can also help avoid disputes between heirs about whether money should be spent on care or preserved for inheritance. Here are 3 examples. So we have David, age 45. He funds an Asset Flex with a pay to 65 plan for a total of $100,000 of premiums. His care pool grows to over $1.3 million by age 85. He did use his benefit mostly, but still was able to leave a residual death benefit of $17,803 to his beneficiaries. Mark, age 62, made 5 annual payments of $20,000. He passed away unexpectedly, and his beneficiaries received nearly $150,000 as a legacy. And finally, Kathy, age 53, made a $100,000 single payment. Later, at age 58, she exercised her return of premium option to help her daughter pay for graduate school. Each story highlights the flexibility Asset Flex offers across different client situations. Not all clients, however, are most concerned about long-term care. For some, the priority is building guaranteed value and growing wealth in a tax-advantaged way. Cash value life insurance creates a pool of assets that can be accessed during life and provides a death benefit for heirs. It can serve as a family bank, helping fund education, emergencies, or even business succession. Our Variable Universal Life Policy, or VUL for short, is designed for clients who want flexibility and growth potential. It offers investment options across asset classes, allows for flexible premiums, and provides death benefit options. Clients can also access tax-advantaged loans from the policy, making it a tool for both protection and accumulation. Whole Life, on the other hand, emphasizes guarantees. It provides steady cash value growth, eligibility for dividends, and a variety of riders that can be tailored to clients' needs. It's predictable, stable, and highly valued for estate planning purposes. When we compare the VUL and Whole Life, the contrast is clear. Whole Life offers guarantees and predictability, while VUL offers flexibility and growth potential. Both can play important roles in providing liquidity for estates and supporting trust funding, and depending on the client's needs and concerns, can be used either separately or together. So, a couple of case studies, right? A client in their 50s with a VUL was able to access cash value loans for long-term care needs while still preserving his estate. In a Whole Life example, a parent purchased a Whole Life policy inside of an ILIT, and upon passing the policy, covered the estate taxes. Both solutions are able to provide estate liquidity and legacy protection. The key takeaway is that estate attorneys and financial professionals are stronger together. Attorneys provide the legal structure, wills, trusts, power of attorney, while we provide the funding solutions. Together, we create comprehensive plans that will actually work when tested. Thank you for your time today. We'd love to explore ways we can work together to protect your clients' estates and ensure their wishes are fulfilled. Please do not hesitate to reach out to both Tommy and myself. Our role is to make sure your legal planning succeeds, no matter what life brings.
Thank you so much, everyone, for a great lecture. Ron, do you maybe have 2 minutes to go over just a couple quick questions? Sorry, you're on.
Yes, yes. I'm
Okay,
happy
so
to.
the lecture is officially over, but we hope you'll stay for these couple questions that we got asked during the lecture. When creating the MAPT, may the grantor act as the trustee, assuming that they do not retain any right to principal?
It's possible. Some of my colleagues do it, but it really is very bad practice. It's better if the creator of the trust, the grantor, the settlor, is not the trustee in the Medicaid Asset Protection Trust. The
Um,
fear is that Medicaid will one day say that the creator has too much control over the principal. That is the fear. Not a great idea.
any thoughts about a designation of standby guardian for young parents?
Yeah, I think that's a great idea, to actually designate a standby guardian. You have families that take a lot of trips and the kids stay behind. It certainly is not a bad idea.
In Connecticut, the principal can appoint their own conservator in a healthcare proxy or POA. Can we do that in New York?
Where the principal of the healthcare proxy could, no, I don't believe so. But what happens is you can appoint someone, but the court would still have to approve it.
Okay. Are RMDs payout status or must the IRA be annuitized?
RMDs are fine in many Medicaid districts. See, it's a little nebulous. So the retirement account is in payout status in New York. Payout status means RMDs in New York City, but in other Medicaid districts like Suffolk County, they have their own Medicaid life expectancy chart that they want you to use, so they they actually get more income.
If the family home is exempt to qualify for Medicaid, can the government go after the house later after the recipient dies, i.e., go after the estate and that house? I had two
If
similar questions to that, and I think you
yes,
touched on
if
it a bit, but
yeah, no, I'll make it very clear. If the home is probated or any other assets are probated, recovery against the probatable asset or an asset that's administered if there's no will, Medicaid is mandated to recover. They have to recover for federal purposes. Otherwise, New York State would not get Medicaid dollars. So that's why we use trust so much. The Medicaid trust, which is irrevocable, and even sometimes a revocable trust just to avoid Medicaid recovery.
right. And one last question. I'm not sure 100% what this is, but can you tell us a little bit about New York State 4x4 plan? I'm not.
No.
Yeah. So it wasn't just me.
Sorry. I
But
don't
I
know what
wanted
that
to
is.
thank you, Ron, Thomas, Evan, for a great lecture. I'm already getting great feedback sent to me. It was a pleasure having you. We hope to do this again with you guys. For all the participants, I will resend the material and the affirmation and the evaluation this afternoon. And any questions that we missed, just shoot me an email and we'll try to get it answered for you. So thanks again, everyone, and we will see you in October.
Thanks,
Thank you
Diana.
so much
Thanks,
for having us.
everyone. Thank
Thank,
you
Thank
to
you.
Judicial Title. Have a great one. See you.
thank you.
Thank you.